They pleaded not guilty and were brought to trial. The trial court, relying on the evidence of PW5, PW7, and PW10, the injured three eyewitnesses held that the prosecution story, insofar as the three appellants, was proved beyond doubt, but the other accused, namely Amrik Singh, Joginder Singh, Kulwant Singh, and Balwant Singh, were entitled to benefit of doubt, and they were accordingly acquitted. The plea of the right of private defense, and that if at all the case fell within the ambit of section 304 part 2 read with section 34 of the IPC, was repealed. An appeal was thereafter taken to the High Court by the three appellants. The appeal was dismissed, leading to the present proceedings. The learned counsel for the appellants has argued that in the light of the fact that Baksh Singh appellant had received an injury in the same incident which had not been explained by the prosecution story itself was in doubt, and the accused appellants were entitled to acquittal on that basis. It has also been pleaded that the trial court had found that four of the accused were not involved in the incident, and it was thus apparent that the present case was one of the false implication on account of animosity between the parties over the construction of the drain. It has finally been pleaded that there was absolutely no evidence to show that the appellants had an intention to commit murder, as the director had opened that the two injuries on Bhutta Singh had been caused by the reverse side of the Gandsai, whereas the other injuries on the person of the PW had been caused with dangs, and as such the case fell under section 304 part 2nd and not under section 302 of the IPC. The learned State Council and the complaint counsel have, however, controverted the stand and pointed out that the trial court and the High Court had given categorical findings that the appellants were involved in a case of murder and had attempted to take the law into their hands and attempted to construct the drain despite the injunction order made by the civil court. We have here the learned counsel for the parties had gone through the record very carefully. We are of the opinion that no fault can be found with the conviction of the appellants in the light of the fact that the prosecution story rests on the evidence of these injured witnesses. The incident is virtually admitted by both sides, although in different circumstances, as the appellant's claim was that Baksh Singh had suffered injuries at the hands of the Gurdial Singh and others, and that the prosecution had suppressed this part of the story. This plea has been rejected by the trial court as well as the High Court, holding that the injuries suffered by Baksh Singh could not be related to the present incident. We are therefore of the opinion that the conviction of the appellants is fully justified on the facts of the case. We, however, feel that a case under section 302 of the IPC is not spelled out. It is clear from the prosecution story that the incident happened all of a sudden when Bhutta Singh objected to the construction of the drain by Gurdial Singh and others in violation of an injunction under in Operation Bhutta Singh was apparently attacked as he was making his way to his fields when he objected to the taking of measurements as a prelude to the diversion of the drain. The evidence shows that some attraction took place on which the three applicants, Gurdial Singh, armed with a gandasai, and the other two with dangs, caused injuries to Bhutta Singh and the PW. We, however, see that the weapons used were in fact implements of common use which are normally carried by villagers all over India, and they do not reflect any prior intention on the part of the accused to commit murder. It also appears that Gurdial Singh had used the gandasai from its blunt side, as would be clear from the evidence of the doctor PW4 who had examined Bhutta Singh on the 11th September 1995 in the Dayanand Medical College Hospital, Ludhiana. He opened that both the injuries on the deceased had been caused by a blunt weapon. We therefore find that if the applicants had intended to murder Bhutta Singh, there was nothing to stop Gurdial Singh from using the gandasai from its two sides, as that would have made it a much more effective weapon. We are therefore of the opinion that the applicants are liable for the offence under IPC.